G'day everybody and welcome to week 7 of Laws 13010 Evidence and Proof. This week we start our 3-week examination of one of the most important rules of evidence, and that is the hearsay rule. The hearsay rule, for some reason, really seems to trip a lot of students up. It's one of those things that seems so tantalizingly easy to understand until you actually start trying to apply the thing and realize that it can be a lot more complicated than what it seemed. Or alternatively, it seems easy when you try and think about it in general terms, but then when you try and explain the rule specifically, it gets a lot harder. In fact, to me, the hearsay rule is really quite simple as long as you don't overthink it. So what we're going to do this week is talk about the rule against hearsay in general, and we're going to distinguish between different types of statement and whether they are hearsay or whether they aren't hearsay. And then in the coming weeks we're going to look at some of the exceptions to the hearsay rule. So what is the rule against hearsay? We've already come across the rule against hearsay a couple of times in previous weeks, and I think it's probably no news to you by now that hearsay is evidence of a statement made by a person outside the court, made by a person prior to the court case. So hearsay evidence is where somebody gets up in the court and instead of saying, "This is something I observed," they say, "This is something that Jane told me." So they don't actually know it themselves, they're repeating things that were told to them outside the court. Hearsay evidence is inadmissible if what you're trying to prove is that the contents of the statement are true. Hearsay evidence is not inadmissible, and in fact it's not even hearsay evidence, if all you're trying to prove is that the statement was said. Some of you are probably scratching your heads about now because that can be a kind of a subtle point to get. I think it'll become a lot more clear once we talk about the key case in hearsay. Never answer a hearsay question in an exam without referring to this one. The famous case of Subramaniam and the public prosecutor. This case came from Malaya, when Malaya was still part of the British Empire. Subramaniam, according to him anyway, was accosted by a group of Chinese communists. He was taken away to their terrorist camp and he was forced to become a terrorist fighter on behalf of communism in Malaya, which is now Malaysia. The communist camp was busted after a period of time. Most of the bad guys got away, but Subramaniam was caught and he was still in possession of 20 rounds of ammunition. At this point in time, the possession of ammunition in Malaya was forbidden because, of course, there was a insurrection going on. And so, after he was caught with these 20 rounds of ammunition on his person, he was sentenced to death. Naturally, he appealed. I'd appeal too. His argument was that he had been walking along, going about his merry way one day, when he'd been accosted by a group of Chinese communists, and they had said to him, "We are communists. If you do not join us, we will kill you and we will kill others." Now, what should the court make of that evidence? On the one hand, it's hearsay, because we don't know whether these Chinese terrorists were going to kill anybody. But on the other hand, Subramaniam actually heard this with his own ears, which means it's something he detected with his own 5 senses. So why shouldn't he be able to tell the court what he heard? It's a conundrum. The answer is, it depends on what we're trying to prove. If we're trying to prove that Subramaniam heard the communists say these words, if he heard the terrorist make the threat, and that's what caused him to go back to the camp, it's not hearsay, because he's just telling us what he heard with his own ears, and he's explaining how he reacted to what he heard with his own ears. If, however, we were using Subramaniam's statement to prove that the other guy actually was a Chinese terrorist, that would be hearsay, because we don't know, and in fact Subramaniam at that time did not know whether the person was a Chinese terrorist. All he's really doing is passing along the words. If he's just passing along the words, it's hearsay evidence. So if you're trying to use the statement to prove that the contents of the statement are true, then it's a hearsay use. If you're just trying to prove that the words were said, then it's not a hearsay use, and the hearsay rule does not apply. That's Subramaniam. Let's take those facts in Subramaniam and simplify them a little bit. On the slide headed "The use of the prior statement," I've put up a very simple statement. Dave said, "I punched his lights out." Now, if I was there when Dave said that, and I'm later giving evidence, it's admissible to prove that Dave was boasting, because I can say to the court, well, when I was there, Dave said I punched his lights out. It doesn't actually matter whether it's true or not. All that matters is that I heard Dave make the boast. I heard it with my own 5 senses, so it's admissible. But if the court's trying to prove actually whether Dave punched anyone, my evidence is useless. My evidence is just hearsay, because I don't know whether Dave punched anyone's lights out. All I know is that Dave said he punched someone's lights out. So in the second case, if they're trying to actually use this evidence to prove that Dave punched somebody's lights out, it's a hearsay use and it's not admissible. So the fundamental rule against hearsay is that you cannot give evidence of something that was said by someone else if the intention is to prove that the contents of that statement were actually true. Now, if at this point you're pressing pause, going back to the start of the lecture and listening to it over again, that's fine. I strongly suggest you have a read of the notes, and also the notes out of field that explain this concept as well. Please don't go on with this lecture until you're really comfortable with the concept of the difference between a hearsay and a non-hearsay use of the statement, because if you can't get your head around that at this point, the rest of the next 3 weeks are not going to make terribly much sense to you. So it's worth taking the time now to really bed down the idea of what a hearsay use and a non-hearsay use of a particular statement is. On the basis that you understand that, let's go on. Why do we have a hearsay rule? There's 4 reasons. The first one is that hearsay is obviously less reliable than non-hearsay rules. Let's say Dave said he punched his lights out, and we've got a choice between bringing Dave into the witness box and bringing someone else in the witness box who merely heard Dave boasting. Who's going to be able to give the better evidence? Clearly, Dave is going to be able to give the better evidence, because Dave is the one who can actually tell us what happened. The hearsay evidence is always going to be less useful and less reliable than evidence from the person who actually observed the events in question. Second, we said last week that one of the key rights of a party is the right to cross-examine the evidence against them. Now, if Dave said, "I punched his lights out," but we don't actually bring Dave into the court, the other side doesn't get the opportunity to cross-examine Dave. Why shouldn't they have that opportunity? Why should the other side miss out on the right to cross-examine the source of the statement just because we've hidden the source of the statement from the court by bringing someone else in to give hearsay evidence? That's why the court says we won't take the hearsay evidence, we want to hear from the original maker of the statement. The third thing is, we spoke a few weeks ago about the importance of an oath and the fact that somebody who's giving evidence in a courtroom is subject to potential penalties if they don't tell the truth. Someone who's boasting over a couple of beers is not subject to the same sort of compulsion to tell the truth. So if somebody's making hearsay statements in a situation where there's no compulsion to tell the truth, why should we treat those statements as being as credible as statements which are made in the courtroom under oath. Truth is that we shouldn't. Finally, in a system where we rely on juries to make decisions, it may be very difficult for juries to distinguish between the appropriate weight to be given to hearsay evidence as opposed to direct observational evidence. And if there's a danger that the juries will give hearsay evidence too much weight, perhaps we're best to keep hearsay evidence out of the courts altogether. As a result of those 4 rationales, the general rule is that hearsay evidence won't be admitted. That's it. That's the rule against hearsay. For the next 2.5 weeks, we're going to talk about all the exceptions to that rule. In order to get to those exceptions, we have to start with the concept of first-hand and remote hearsay. So hearsay itself is divided into 2 subcategories. First-hand hearsay occurs when the person giving evidence heard the statement from a second person, but that second person was the one who actually made the observations. Remote hearsay happens when the person who made the observations is even more remote from the person who's giving evidence in the court at the moment. So we've got an example there in the slide. Dave says to Carl, "I knew I'd had a few too many, but I decided to drive anyway." Carl then says to Anna, "Dave told me he knew he'd had a few too many, but he decided to drive anyway." The best evidence, of course, would be to get Dave in court and say, "Dave, did you know you'd had a few too many? And did you decide to drive anyway?" That wouldn't be hearsay. That'd be direct observational evidence of what Dave himself experienced, and there'd be no problem. But we're not going to call Dave. Instead, we're going to call Carl. And Carl gets into the court and says, "Dave told me he knew he'd had a few too many, but he decided to drive anyway." That's hearsay, because Dave doesn't know whether Carl doesn't know whether Dave had had a few too many. All Carl knows is that Dave said he'd had a few too many. That's first-hand hearsay, because Carl has heard it directly from Dave. So Carl, the witness, has heard it directly from Dave, the drink driver. Carl, the witness, then turns around and tells it to Anna. What would happen if we got Anna into the court? Anna would only be able to say, "Dave told Carl, and Carl told me that Dave had told Carl that he had a few too many, but he decided to drive anyway." What you can see is that Anna's evidence is remote. There's really too many jumps in the communication between the person who actually knew what was going on and the person who's sitting there in the court. When we talk about the exceptions to the hearsay rule, they will almost only ever apply to first-hand hearsay. So for the exception to apply, we have to be confident that the person sitting there in the witness box heard it from someone, and the person they heard it from actually observed with their own 5 senses what was going on. If there's any more than that one jump in the communication chain, the evidence is not going to be admissible, because the chances of error just compound and compound and compound. I'm sure you've all played the game of Chinese whispers as children, where a message starts and it goes around a circle of 15 or 20 people, and at the end of the message being passed from ear to ear, it ends up bearing very little or no resemblance to the message that started. We're not going to convict people of criminal offences or make verdicts in civil cases on the basis of Chinese whispers. So first-hand hearsay is all you're ever going to get away with. The second concept we need to revise before going along and having a look at the exceptions is the question of prejudice and proof, because this is the question the court is always going to be asking in relation to hearsay. Is this hearsay evidence probative, or is it just prejudicial? Is it actually going to help us to make a decision about the facts, or is it actually going to get in the way by clouding our thinking and diverting our thoughts into areas other than the logical proof of those facts? balance between probative and prejudice value is something that I'll be talking to you a lot about in the next couple of weeks. So that's the concept of hearsay. Let's start to apply it now in a few different ways. Last week I said that documents were a form of hearsay, and I promised that once we had introduced the hearsay rule, I would come back to that idea and we would visit it again. Let's do that right now. In the case of oral hearsay, we have a chain of communication, all of which is mouth to ear. So Stacey told Dave something, and Dave told the court what Stacey had told him. That's the sort of hearsay that we've just been talking about a few moments ago. That's the classic Subramaniam style of hearsay. What if, instead of Stacey telling Dave anything, she'd written it down in an email? And then instead of Dave coming to the court to give evidence, Dave had simply produced the email, and the email had been tendered as a document. What you can see is it's exactly the same thing. In both cases, the person who's in the court giving the actual evidence, whether it be oral evidence or documentary evidence, that person has no direct understanding of what happened at all. They're relying on what somebody else is telling them. In neither case is Stacey able to be cross-examined, and in neither case did Stacey make her original communication under oath. So you can see, in every way that matters, the communications are exactly the same between oral hearsay and the production of a document. So now hopefully that makes it clear what we mean when we say that all documents, or virtually all documents, are hearsay, because they all occur in a situation where some person is recording their observations on paper or in documentary form, and then instead of that person showing up to court to say what they saw, the document is being produced as a sort of intermediary, a sort of middleman, to allow that information to get into the court. That doesn't mean documents are bad evidence, but they're always a form of hearsay. One interesting thing about hearsay is that although the hearsay rule is still very strong in most courts, it's under attack in quite a few other institutions. Under the Family Law Act, if you're appearing in the family court, particularly in relation to child-based proceedings, a whole bunch of the rules of evidence don't apply. In particular, the hearsay rule doesn't apply. If you're appearing before the Queensland Consumer and Administrative Tribunal, the rules of evidence don't apply, and particularly the hearsay rule doesn't apply. So don't automatically assume that the rules of evidence included in the hearsay rule are going to apply in every court or tribunal that you ever appear in. They will apply in most, but in some cases, particularly cases like QCAT where they're not necessarily playing for sheep stations, it can be sensible to allow limited amounts of hearsay evidence to be put before the court. Bear in mind though, hearsay evidence is always second best, and hearsay evidence is usually going to be defeated by oral evidence from a person who actually knows what they're talking about. The hearsay rule itself is not that difficult to understand, and if you're still with me at this point, then you've probably got a pretty decent understanding of what the hearsay rule itself actually is. Where the hearsay rule becomes tricky, however, is that there are a whole bunch of exceptions, and understanding the application of the hearsay rule in evidence law is actually all about understanding those exceptions. We can run through them very briefly now just to provide a sort of a roadmap for what they are, and then we'll start to have a look at them. There's admissions and confessions, statements which formed part of the action, statements made by people setting out their thoughts and feelings at the time of the event, statements of people who are now dead and therefore not available to be cross-examined, statements where somebody puts down the phone and says, "That was Bob," which the court will usually take in these days as evidence that it really was Bob, and statements by expert witnesses who are drawing on the knowledge of their field. So if an expert witness gets up and says, such and such an economic expert has said this, even though theoretically we could try and go to the United States and get the economic expert to come to Australia and give evidence, in reality, if we have an expert witness who's giving evidence based on the accumulated expertise of their area of learning, we're going to let them off the hook. The other exception, and the one that we'll deal with for the rest of this week, is an exception where a witness has made prior statements that are inconsistent with the evidence that they're giving in court. If you go right back to week one of the things that we talked about, and that's been a theme through this course, is the ways in which we can challenge evidence. We said we can challenge evidence for being unreliable. We can challenge evidence for being irrelevant. We can challenge evidence as being inadmissible. We can challenge evidence for being unreliable, and we can challenge evidence for having low probative value. One of the big issues with witnesses is the reliability of the witness. And the reliability of the witness matters because we know that oral evidence is affected by the limitations of perception, the limitations of comprehension, the limitations of memory, and the limitations of honesty. What happens if a witness makes a statement in the lead up to the court and then they get into the witness box and they say something completely different? It tells us that they're lying, or it tells us that they were lying, because they've made these two inconsistent statements. At the very least, it tells us that perhaps we can't really rely on what this witness is telling us in court. If they've told one story to the police and they're telling another story to the judge, it starts to suggest that this is not a witness that we should be placing great reliance on. And so if we're trying to knock out the other side's evidence, one great way to do that is to show that the evidence is unreliable because it's inconsistent with a statement that was made outside the court. There are a number of types of statement outside the court that are going to be relevant to the credit of a person. Those statements are generally going to be admissible outside the hearsay rule. So the hearsay rule will not stop us from admitting these sorts of statements. There are a few different types. The first is where they've made a prior inconsistent statement. That's the situation we've just talked about, where they tell the police one thing and they tell a judge another. Second is a witness who's got a reputation for lying. A witness who can't be trusted because they tell lies all the time. Third is a witness who has previously expressed a bias, and the bias is likely to affect the evidence that they give in the case. The fourth one is one that will outrage a few of you, but we'll go through it anyway, and that's a situation where a witness in a case involving a sexual offence has failed to complain at the first reasonable opportunity. And the final one is a situation where it's alleged that the witness has recently invented their complaint. All of these are situations where, if you're trying to suggest that one of those things is true about the witness, you're almost going to have to introduce evidence about things that they've said before the court hearing. Because if you don't, you're going to have a hard time asserting these things about the witness. Usually you'll be entitled to. Why? Well, primarily because the point that you're trying to make is not that the content of the previous statement was true. In fact, you might be trying to assert that the content of the previous statement was utter rubbish. What you're trying to assert is simply that the witness is unreliable. So you're using the evidence for a non-hearsay purpose. That's why it's going to be admissible. Let's have a look at some of these in detail. Let's start with prior inconsistent statements. In the Crown and Soma, he told the police that when he had met the victim out in the front yard, he had pushed the victim to the ground and harmed her. He then got into the court and he said that nothing of the sort had ever happened. So he's changed his story to a story in court which makes him seem far more innocent than he seemed when he was first talking to the police. What are you going to do about that if you're prosecuting? You've expected him to say one story and he's come up with something completely different. You know that what he's saying in the court is different to what he was saying in the police. The way that you have to deal with this is first put the prior statement to him in cross-examination. So you say to the person, what you've just told the judge in your examination in chief, that's completely different to what you told the police when they interviewed you 6 weeks ago, isn't it? Because when you talked to the police 6 weeks ago, you said this, didn't you? Give them an opportunity to explain the discrepancy. Now, if they admit that they made that proper statement, you can say, well, why are you telling us a different story now? How can you explain what the difference is between what you're telling us now and what you were telling the police 6 weeks ago? If they can't come up with a good explanation, well then the court's going to be pretty quickly able to assess their credibility for itself. If they refuse to admit that they made the prior statement, well then that's your cue to call another witness, presumably the person that they made the statement to, and that person can give evidence of the statement that was made outside the court. Now ordinarily you'd think that that evidence is hearsay, but in this case it's not, because it's the only way the court can resolve the question of whether the prior inconsistent statement was made outside the courtroom. So a prior inconsistent statement can be tendered as evidence even though it was made outside the courtroom, even though it was made not under oath, because the purpose of it is to show that the witness has changed their story and therefore the witness is unreliable. The second example we referred to was asserting a bias. Someone has a bias in this context when they're willing to lie under oath in order to secure an outcome. Nichols and the Queen is a complicated case, and I won't try and go through all the facts of it, but essentially what happened was that Nichols stated to another prisoner that one prisoner stated to another prisoner that he'd been offered a deal by the police and he was going to go in and give false evidence in order to cut that deal from the police. So you can see that the witness in that case was not motivated by a desire to tell the truth. The evidence that they were giving was not based on what they'd seen and observed. It was based on what was going to secure them an outcome from the police. So the witness was a biased witness. Now in that case, you would be quite entitled to bring the second prisoner into the courtroom and get that prisoner to say, this is what old mate told me out in the prison yard. Because it enables you to make the argument that the witness, the current witness, who's now denying that they did anything of the sort, is unreliable. The third one, and this will outrage some of you, there is a rule in the common law which has been passed down through the centuries that holds that when a person, and statistically that means when a woman, is a victim of a sexual offence, they are required to immediately complain. So they must make their complaint at the first available opportunity, and if they did not, their failure to complain at the first opportunity was regarded as evidence of consent to the sexual activity. Now for those of you who are pulling your most appalled face at the moment, I can't see the logic in it either, but this is the rule that came down through the common law. Strangely enough, a version of this rule remains in force in Queensland under statute. So the statute says evidence of how and when any preliminary complaint was made by the complainant about the alleged commission of the offence by the defendant is admissible in evidence regardless of when the preliminary complaint was made. So you can actually question a witness still about the circumstances in which they made their preliminary complaint. This means that if a witness has not made their complaint for 6 or 8 weeks after the event, it's quite legitimate to ask them why they didn't complain sooner, why they maintained their silence. Fortunately, the situation is not quite as unenlightened as it seems at the moment. The key case in this area is Kilby and the Crown. Kilby and the Crown happened nearly 40 years ago, and in this case a girl ran off with a group of bikies and was allegedly pack raped by a group of them, but didn't actually advise anybody that this had happened for a period of some weeks after the offence. And the court found that the fact that she hadn't complained early was a factor that should be taken into account in terms of her credibility when she made the complaint in the end. Wind the clock on 40 years, and we now have a much greater understanding of the psychological impact of sexual offences. We now have a much greater understanding of the level of courage that is required for the victim of a sexual offence to come forward and actually make their complaint. These days, it is most unlikely that a delay in the complaint by a complainant is going to be held against them in terms of credibility. However, the circumstances in which they made their complaint are going to be relevant to the question of how much credibility they can be given. So, if the complaint was made in circumstances which make it clear that there are questions to be asked about whether they were telling the truth or whether they were trying to preserve their own reputation, for instance, within their group of friends by asserting that they didn't participate in certain sexual activity consensually, that's an argument that can be run by the defence on the basis of the timing and the nature of the complaint that was made by the complainant. So that's a question that goes immediately to the complainant's credibility, and it's a question that's built upon evidence of something the complainant said outside the court. Yet again, that would ordinarily be a form of hearsay, but in this case it's not being used to question whether or not the complaint was accurate. It's being used to consider whether or not the person making the complaint was credible. Now, I have to say, I've given you a very, very brief overview of that question about failure to complain in sexual offences. It's actually a very complicated topic, and I could probably present a 45-minute lecture just on that question. So, if you're still appalled at the end of that explanation, that's fine, but it's probably time to do some additional reading rather than simply remain appalled on the basis of a 5-minute overview. The final one we need to talk about is the suggestion of recent invention. A suggestion of recent invention is where you suggest that a witness has kind of made stuff up in order to give evidence before the court. So they've suddenly realised, well look, I've got to give evidence before the court here. I might have to come up with a story. I might have to come up with something to tell the court. And I'm probably going to come up with a tale that reinforces the prospects of the side that I would prefer to win. Obviously, if a witness is recently inventing certain aspects of their evidence, and if that can be demonstrated, then that's going to impact on their credibility as a witness. In the case Nominal Defendant and Clements, which is a 1960 case, a child was hit by a motor vehicle and was claiming damages as a result of that accident. One of the key questions in the case was whether the child was standing beside the road when struck, or whether the child had actually pursued a football onto the road and was struck by the car as a result of running onto the road in order to chase the football. And that would obviously have a fairly key importance in terms of the liability of the driver. When the witness came to the court, the witness was about 13, and it was 6 years after the actual incident, and the witness gave evidence that he had been standing on the footpath. The defence quite rightly argued that given that the events that were being discussed had happened almost half the witness's lifetime ago, it was most unlikely that the witness's evidence about his location when he was hit was actually reliable, and that in fact it was far more likely that the witness had recently invented that aspect of his evidence. Because that suggestion of recent invention had been made, the side that called the child as a witness was then able to draw upon a statement the witness had made to police very soon after the accident, where the witness had said that he was standing on the side of the road on the footpath. So they were able to say, hang on, this is not something the witness has made up now in 1960, because here we have a police statement from 1954 where the witness said the same thing. That pretty neatly rebuts the suggestion of recent invention. But in order to get there, in order to get to that rebuttal, you have to be able to draw on statements that were made outside the court in circumstances which would normally make them hearsay statements. And why is that okay? Because you're not relying on the statement to prove the contents of the statement. All you're relying on is the statement as evidence that the statement was made. This is why, if you think about the start of this lecture, it's so important to understand the difference between a hearsay and a non-hearsay use of an out-of-court statement. So what have we looked at this week? We've looked at the question of what the hearsay rule actually says. The fact that the hearsay rule says you cannot use statements that were made out of court by a third party as evidence to prove the contents of those statements. We've then looked at non-hearsay uses. So we've said you can probably use these statements to prove just about anything else. In particular, you can use the fact that someone's heard these statements made as evidence that the statements actually were made. We've then looked at the fact that there's a whole bunch of exceptions to the hearsay rule. And we've started this week by looking at the exceptions which relate to proving or disproving the credibility of the witness. Next week we're going to have a look at admissions and confessions, because admissions and confessions are a very special form of hearsay, mainly because they're so powerful. If there's an admission or a confession and it's going to be believed, that's pretty much the case, done and dusted right there. So clearly we have to have special rules to make sure that only admissions and confessions which can really be trusted are going to be admitted before the court. The following lecture we're going to look at a whole bunch of other exceptions that we'll run through one at a time to see why the court considers that each of those exceptions have a greater probative value than the prejudicial risk. So I hope hearsay is starting to make sense. Have a look this week at an episode from the famous and by now quite old series Rumpole of the Bailey. This is actually the first episode. It's called Rumpole and the Younger Generation. In it we hear the story of an alleged confession, which is a hearsay confession, by one young offender to another young offender, and it turns out that the confession is not quite what it seems. And Rumpole, through cross-examination and through adroit use of the hearsay rule, is able to show that that's the case. I hope you enjoy Rumpole of the Bailey, particular for those of you who are from the younger generation and who are perhaps discovering Rumpole for the first time. And I'll look forward to taking up hearsay again when we speak next week.